You know, I have to re-say this. It reaffirms our right as First Nations people.
We've been practicing traditional medicine all along, and we're still here. We're growing bigger and bigger. We're not going anywhere.
Well, sadly, one member of their community has gone somewhere. A girl by the name of Makayla has died. 11-year-old girl who suffered from a rare form of leukemia with nearly a 90% survival rate if she had received chemotherapy. There's that beautiful little girl right there. At the time, of course, Makayla said that she had seen a vision of Jesus Christ who told her that he had healed her and that she no longer needed to receive any type of so-called Western medicine. All right, there's all sorts of aspects of this to break down. At the time when this court ruling came out on another case, very similar situation, I was personally aghast. But Ed Prutschi is our legal affairs analyst, and Dr. Brett Belchetz is our medical affairs expert here at Sun News. So we've got the legal and the medical aspect. I'm going to start with you, Brett. Were you, at the very least, were you surprised at all when you heard that this little girl had died?
No, I wasn't surprised at all when I heard that she died. This is not a survivable illness without a full course of chemotherapy. There is not one case in history of a patient surviving this form of leukemia without completing chemotherapy. So the decision to not go through a treatment was basically imposing a death sentence on this girl. And I am completely mortified and upset. This is a travesty, and this is a tragedy that was avoidable. We
showed those clips from the First Nations community outside of Hamilton, Ed, at the time when the court ruling came down on a very similar case, almost the parallel case that unfolded. JJ, they referred to her. The judge said we cannot impose Western medicine on Aboriginal communities, on the Native communities. Brett calls it a death sentence. I did as well at the time. Do you agree? Did the judge issue a death sentence to this girl?
Look, it clearly is a death sentence. It's hyperbolic and that's aggressive, and it sort of gets that reaction. But you can't deny that that's the reality of it. I don't think the Native communities, frankly, can deny that it was ultimately a death sentence. There was no reason to believe that short medical treatment, this girl was going to survive. No reason to believe that. So the question then becomes whether a child of that age in that community, for a variety of legal reasons, whether she ought to be able to make the choice, or who ought to be able to make the choice to allow her to die. Now, it was never phrased that way. It was never couched that way in the courts, and I think that's problematic because that glossed over the reality of what was going on here.
You and I have talked on a number of occasions on the responsibilities of medical professionals when it comes to drinking and driving. It's a passionate issue for you, I understand. But this case was brought forward because of McMaster University. The healthcare professionals there clearly wanted this little girl to get help. The other girl, but again, similar situation. Makayla withdrew from chemotherapy voluntarily because of her parents allowing that. But she's 11, she can't make her own decisions. She could have received the chemotherapy. No parent wants to see their child go through anything. It's hell on parents to see your child suffer in any way, shape, or form. And yes, of course, Brett, chemo for a little person, any person, it's hard, it's poison. We all understand that. But wouldn't she have received a certain regimen for a certain period of time and then wouldn't have tapered off over the course of the next couple of years? So I guess my question to you is this. What point do we say you as a medical professional have the right over a parent? Because this judge ruled that what you say is irrelevant, not you as specifically, but you as a medical professional. Doesn't matter what you say. Aboriginal healing is taking precedence.
So I was stunned by this decision on the part of the judge because it backtracks on decades of the way it's always been defined within the medical profession, that our responsibility when dealing with children is the health of the child. And if a parent is making decisions to withhold treatment that every medical professional says is necessary for the health of the child, then it is decided that that is actually child abuse. And nowhere ever in any of my ethics teaching or any medical training did anybody say that if religion was involved in that teaching or religion was involved in that decision making, that was an excuse to make decisions that could harm or kill your child.
And we know, Adrian, that that's not the case. I mean, to jump in there, because we know that in other scenarios, in the non-Aboriginal sphere, the courts have upheld and frequently injected themselves into these scenarios and said we are not going to permit, for example, Jehovah's Witnesses when it comes to blood transfusions.
Supreme Court ruled on that.
And I've certainly seen a number of clients of mine and cases that I've followed in which parents have given various excuses, whether they're socioeconomic, whether they're religious in nature, or whatever their faith-based healing is, to say this is why we didn't seek out treatment or this is why we did alternative treatment. Those people end up getting charged with failing to provide the necessities of life, an element of child abuse, and they can potentially go to jail. Everybody is tiptoeing around this because it's an Aboriginal issue, and rightly so. We should be careful with how we discuss it, and we have to be cognizant and somewhat sympathetic to that unique scenario. But what makes the Aboriginal situation so different that it permits basically reliance on something we know to be wrong? I mean, I even question the Aboriginal nature of it, because this little girl talked very eloquently, but she talked very eloquently about Jesus coming to save her. That's not really about Aboriginal people.
And I'm going to agree with you. This is not about Aboriginal treatment. So the treatment that she went for, she went down to a center in Florida.
This guy's a quack, Brett.
Called the Hippocrates Center.
And she got massages and ionic colon hydrotherapy, straw diet. I mean, come on.
Yeah, the gentleman that runs this center claims to be a naturopathic doctor, and he's not even that. He has no qualifications whatsoever. So part of the decision-making process on the part of this family to withdraw her from chemo was this gentleman, who has no medical training of any kind, his assurances that through alternative therapies that nobody quite understands, that he could cure her of cancer. So this was not Aboriginal decision-making. This was listening to a fraud and a quack. And the fact that somehow this girl was not protected against a totally fraudulent medical center's claims that they could cure her says that our system let her down. I think this is an absolute travesty.
I agree with you, but her parents let her down first and foremost. Her parents, they are the first and foremost for a duty to care for their child. Well, they let her down.
I don't disagree with you. So from medical ethics perspective, I think there's two things that we look at when we look at a minor making decisions about medical care. So there is no magic age at which a minor can make their own decisions, but there are things that we look at. So number one, they as a minor have to understand the implications of their decisions. So when I speak to a minor who says, I don't want care, they have to fully, in a mature adult fashion, say, I get what this is going to end up in. So her only answer that would have said she's competent to withdraw herself from care would have been she understood that she would die without this treatment. She never gave that answer. She was convinced she would live. So she didn't understand the implications, which means that she shouldn't have had the ability to make her own decision there. The other scenario is she did understand the decision or the implications of the decision that she would die, and she was suicidal. And equally in our medical care system, we say somebody who is suicidal is now deemed incompetent under the Mental Health Act to make decisions, and we take the right away from her. So either she didn't understand and then she's not capable, or she did understand and she's suicidal. One way or another, the fact that we let her make this decision is not appropriate.
There is potential for appeals on this particular ruling, and I would like to note that the same judge was involved in another case, again, same type of leukemia, same First Nations group, the whole thing. Is there a potential for someone to hold Children's Aid Service accountable for this? Because they put the file aside and said, we're not going to pursue this any further. What can happen here?
So one of the unique situations in this particular case, or in both of these cases, is that the Children's Aid Services were on the side of the parents, on the side of the child, and they did not side with the hospital. Typically when we see intervention in sort of faith-based healing scenarios, it's because Children's Aid comes forward, brings the application themselves, and in fact sides with the hospital and says, you know what, the parents are making a negative decision for the child, a potentially fatal decision for the child, and therefore this is what's defined under our Children's Aid legislation as a child in need of protection. And so they seize the child for a temporary period of time, they provide the appropriate medical care, they then return the child to that home. That's not what happened here. We had Children's Aid actually taking the position that this was an appropriate decision by the parents. So if you're critical of the parents, you're equally critical of Children's Aid. In terms of whether or not we're going to see any appeals, unfortunately, tragically, the decision is moot. I mean, one could appeal it just for the academic precedential value, although I don't see the hospital being interested in that right now. But the reality is the child is passed. There's no case to argue anymore.
I think there does need to be a review of how Children's Aid came to that decision, and I don't know how that would come to be, but when you look at the quotes coming from Children's Aid, they very specifically said, we are not in a position to understand the medical decision making here. That's not our area of expertise. We are here to figure out if there's abuse, and we've decided there's no abuse. Well, the actual medical decision making was what this case hinged on. And if they were not going to listen to the experts there or do the research to understand what would have been actually appropriate medical care, I think they abrogated all of their responsibilities. And I think somebody needs to look at that and say, going forward, Children's Aid can't say we're going to ignore the medical side of the equation.
I want to just touch on another important aspect of this on the medical side, Brett. She died, she suffered a stroke on Sunday and died on Monday. The statement that came out from her parents said that chemotherapy did irreversible damage to her heart and major organs. Other medical experts are saying that there's no clinical precedent for chemotherapy drugs to have prompted a stroke in a childhood stroke several months after treatment. So Can you unwind that for me a little bit?
Well, I think the statement that this was due to chemotherapy is nonsense. So chemotherapy months after does not cause a stroke.
Okay.
This is just blatant dishonesty, and this is an unwillingness to take responsibility
But
for
stroke is consistent with a leukemia
Stroke
patient.
is well known to be a potential complication of out-of-control leukemia that has recurred. So this family is refusing to face the fact that their decisions killed their little girl.
I mentioned that there is another little girl in a very similar situation, which brought up the original court case, Ed. Is there a potential for the case to be appealed in the sense that the judge's actions have to be reviewed? Like, does any of that happen?
That potentially
'Cause,
exists,
here's the
but
question,
someone has to take those
Here's the
steps.
question every Canadian's asking themselves: who's responsible for this? How did this happen? And if this other little girl dies, who also went to the same quack at this
Well, she will. I
Hippocratic,
mean, it's terrible to say it, but
yeah.
she will. If things continue as they are now, I mean, we've heard from Brett. We know what the medical answer is. Unfortunately, it's just a matter of time. One can appeal the decision. I think we need to bring some nuance to this, though, because the reality is I'm sympathetic with the position the judge is placed in and what possible answers he can give. I just don't like the judgment as it stands now, which is easy for me to say, but hard for me to then articulate what I would otherwise do, because the alternative is a situation in which potentially you're going to be taking an 11-year-old against her will. It may require physical compulsion to hold her down and administer against her will chemotherapy while her parents are compelled to stand somewhere else, potentially in some sort of custodial setting, while we do this against their will as well. That is a tragedy. It maybe isn't the same travesty as allowing a child to pass when you could have saved that child, but there are no easy answers here. So if there's going to be an appeal,
I get that,
the
but-
hospital has to
I'm going
drive
to
it.
interrupt. So when people are suicidal, we strap them down. Even if they're 11 years old, we strap them down and we force care on them, and we do that every single day in every one of our hospitals in this country. This is no different. So to allow this girl to die is completely against all ethics of this type of situation. And yes, that's horrible, but we are failing her if we do not do those terrible steps that are necessary to save her life.
This girl was failed indeed. All right, gentlemen, great discussion.